This session, of course, is a continuation of Professional Practice 1.0, so we call it Professional Practice 2.0. So this is a continuation of that last chapter, Chapter 4, which is where I indicated that it's quite substantial, so you really need to look at that very carefully. Okay, so let's continuing on here. So the next thing in professional practice, of course, is forgery and fraud. And that should be perfectly obvious. You should not forge your client's signature, okay, essentially. So in other words, you signing because you went to see the client that night and you missed a signature. And your client is gone, maybe on a holiday perhaps, or you can't get a hold of them, or you yourself are basically saying, I don't want to go all the way back there just to get a signature, so I'm just going to forge that individual. I'm going to sign on that behalf and on that client, whatever. If that is found, then you are forging the client's signature and everything else. That is a clear violation of the law. That in fact is a criminal act. Forgery is a criminal act, and so you could find yourself in front of a criminal court doing that kind of thing there. So forging somebody's signature, signing somebody else's check, things of that nature there, it's an absolute no-no. It's just under no circumstances should you ever do that. So if you find yourself in a situation where you missed a signature or whatever and you can't get a hold of the client, my recommendation would be to very quickly send a letter to the client saying, Mr. Jones, my apologies, I missed the signature, I need to come and see you as soon as possible, but in the meantime I will hold on to your application until you return, but should be aware of that. The coverage is not there because I did miss that signature. That sort of protects you. So, but forging your signature, that definitely is absolutely not. Okay. Fraud, okay, is the same. Falls under again the criminal act. So fraud, okay, and again you are trying to deceive somebody. Remember that both in forgery and fraud, there was an intentional act to deceive. Okay, unlike a mistake where you have no intention of making a mistake. You don't sort of get up in the morning and say, I'm going to go out and make a mistake or something, but we all make mistakes, okay? These forgery and fraud, basically, these are, in fact, real situations where you thought about this and you decided that you're going to do so. Forgery and fraud are intentional. And that's why you'll notice in law that there's no statute of limitation on forgery and fraud. So this could be a situation where they found out 10 years down the line that you did this, and the law still upholds that you're responsible for committing that fraud or that forgery or whatever. So there's no statute of limitation on criminal offenses. The next one is trafficking. Now, some of you may wonder, trafficking of insurance policies, that's the most unusual thing, whatever it is. But trafficking we're talking about here is where, in fact, you are inducing your client to sell you their life insurance policy. So, for example, you have a client who's in dire need of money. They have an insurance policy, $100,000, whatever the case may be. Okay, usually they're older people that may have financial difficulties. They may have medical issues, so they need cash, and they need cash now. The money's not going to get paid out until the actual person dies, when the person actually dies and everything else, okay? So therefore, in the meantime, they're in financial constraints and everything else. So you, as an agent, will go there and buy that contract from them. So, 20 cents, 30 cents on the dollar, whatever it is, And of course, now that you own that policy, basically you name the beneficiary yourself, and you essentially wait until the client dies, and then you get the money. But trafficking is illegal in Canada, okay? Some of you may be familiar with another name instead of trafficking, what they call life settlements. In other words, again, same idea, you're buying an insurance policy from somebody else, and now you own it. You remember that you can always transfer ownership, okay, on an absolute basis. If you remember in previous webinars that we had an absolute assignment session. So that's nothing wrong with absolute assignments. It's when you buy that policy. So it's actual purchasing. So that's where the word trafficking comes in, okay? The actual purchasing of the policy, that becomes a problem right there. That is illegal, okay? Some of you may also be familiar with the word viaticals, okay? It's the same idea. So whether it's a life settlement or viaticals, it falls under the trafficking law, basically, so that if you are, in fact, buying a policy from somebody, and usually when you buy these things, you're really taking advantage by saying of a vulnerable individual. They're in dire straits, they need cash, they need whatever. You come along as the white knight, so to speak, to save them. Here's some money, give me the policy, transfer the policy over to me on an absolute basis. I then will change beneficiaries to myself, and then I wait until you die, and I get the money and everything. So you're sort of taking advantage of a very vulnerable situation. So that is strictly controlled these days. Fronting is an interesting one. This is where basically you give a whole pile of applications to, say, to a friend of yours. And because he's got all kinds of friends and so on and so forth, so you give him an application, you say, look, go out there and fill out these applications, do this following. That individual doesn't have a license. You're the one that actually has the license, okay? And so that individual now goes out, writes these policies, but of course can't place the policy because they don't have a license, they have no contracts, they have nothing like that. Gives you those applications. And now you turn around and you sign as the agent and everything, and then you push them through to the insurance company. Okay, so what you're really doing is you are fronting for that individual who doesn't have a license. Okay, so therefore, obviously, there's you're going to remunerate the other person. Say when the case settles, I'll cut you a check. So we'll go back to that commission splitting part of it or that referral part of it. So fronting really is when you act on behalf of somebody else that doesn't have a license. You put it under your name, but you never saw the client. Because if you look at where you're signing, you say, I witnessed blah, 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 blah. I witnessed all this. Well, you didn't. Okay, you didn't. It was somebody else who did all that, and you simply signed on to it, and that's as far as it went. Well, that is a clear violation of the Act. You're supposed to go and witness that particular signature. So the fact that you said I did see them, you're lying, and so that creates a real problem. And once again, it gets up in a whole bunch of trouble. Delaying delivering the policy. This is quite a serious situation in that when I left your house, you were simply, as far as I was concerned, very healthy. You gave me all the information. You gave me a check. You did all the right things and everything else. I gave you the TIA, remember the temporary insurance agreements. Everything is wonderful, right? Now, later on, the policy is ready to be issued, okay? And for whatever reason, I don't have the time to deliver it. I want to go on holidays. In other words, the application of the policy sits on my desk. Many companies say that the policy is not enforced until the policy is actually delivered. So you never deliver the contract. You never deliver the contract because, like I say, you're on holidays. You were busy with other things, and the client ends up dying or becomes disabled or becomes uninsurable. And suddenly you go back to see the client and he's dead, or there is a medical issue and everything. You can't obviously deliver the policy. So you have put the client in a very, very big disadvantage here because there may be no turning back here. There might have been, if the person is dead, that's the end of that. You can't can't insure that person anymore. If a person is seriously ill, you can't deliver the policy. If there's been a material change from the day that you leave your client to the day that you're supposed to deliver the policy, if there's been a material change in your health, occupation, whatever it is during that period of time, okay, you can't deliver the contract. Because it's been a material change. You're putting the company on risk, basically, when in fact there's a material change. So the only way you can place this policy is when you left the client, everything was wonderful, and when you deliver the client the policy, everything is still wonderful. But if there's been any change along the way, you cannot deliver that contract. So delaying delivery could, in fact, jeopardize your client. Eventually, of course, it will jeopardize you as well. Okay? Misrepresentation, that's an obvious. Okay, if you misrepresented your product, you misrepresent the company. You said something that really isn't really true. Okay, you said that the product will do certain things, when in actual fact it won't do those things at all. Okay, so it's basically misrepresentation once again. And if the client can prove that you told them this, in actual fact it's something else altogether. So in other words, the client's expectations were not actually met. You deceived that client, so therefore you misrepresent it. Once again, you could find yourself in a whole bunch of trouble as well. Okay, commingling of funds. Very rare nowadays, but there's a possibility sometimes that the client may actually cut a check to you personally, okay, with the understanding that you would then forward the check on to the insurance company. But instead of doing that, what you do is you deposit that money into your own bank account, basically. And so now what have you done? You have commingled the money from your money as well as your client's money sitting in the same account. So you commingle that. So even though you may actually write a check to the insurance company, the question now comes down to is whose money was it? Where did it actually come? Are you in fact paying the premium for the client because you wrote a check out of your own bank account because you commingled all this? So if the insurance company wants a check directly from the client themselves, right from their own bank account. But like I said, sometimes in circumstances it may be that they may leaving money on deposit with you. You then deposit that into your own bank account, and then you write a check from your bank account. That could create a real problem in commingling and everything. So, moral of the story is, if you're going to do that kind of thing, if that's the way you've done your practice, you really should have a separate account, which is what they call an in-trust account. And so that money really belongs to the insurance company, belongs to your client, and there's no connection between your in-trust account, let's say, and your own personal account. So you're keeping the money separate. But if you just simply deposit it in your bank account, then the question is, where's the paper trail? Whose money is it, and so on. And so you could find yourself in a situation where, now that you're writing this check, it could be a situation of rebating or something, So you got to be very, very careful with that kind of thing. How you hold yourself up. This is basically, what is the public perception of who you are? Like, in other words, when you advertise yourself, what you say in your business card, don't put on your business card that you are something that you're not. Okay? In other words, how you advertise yourself, how you hold yourself out in the public. What is the public perception of who you are? So if all you're really doing is selling, let's say, mortgage insurance, so if you're a mortgage insurance rep, basically, say so. Don't tell the client that you're a financial analyst or something and all you're really doing is selling mortgage insurance. Okay, so if you're going to call yourself a financial planner, then make sure you have financial planning credentials. CFP, CLU, whatever, that sort of stuff there. So the public perception is very, very important. What you call yourself on your business card is very important. If you have a website, okay, what is the public perception? What are you saying in that website? So that, again, a reasonable person, a client, whatever it is, say, okay, well, I believe this is what this person does. Okay, so we'll go back to that duty of care aspect of it as well. So how you hold yourself out is very, very important. Again, the public perception of who you are. Churning and twisting, this is really where you are, in fact, replacing an insurance policy with another company's products. Okay, so churning is when you replace it with the same company. And so I have a product with company X, and I also happen to represent company X. Okay, so you are insured with company X. I represent company X. I come over to see you, and I say, drop your old policy and buy my new policy, basically. So churning is what I refer to as internal replacement. It's replacement within the same with the same insurance company. Twisting, on the other hand, is when you're replacing it with a different insurance company. So you have a policy with company X. I represent company Y, and in the process of doing that, I come over to see you. I say, drop company X, buy my company Y. That is twisting. So when you're replacing it with a different insurance company, then it's twisting. If you're replacing it within the same insurance company, then it's considered churning. Now, there's nothing exactly wrong with what you've done, provided you can prove to the client that it is in their best interest. So again, going back to conflict of interest, make sure your client is first. How do you go about doing that? How do you protect yourself against that? Is right here. Okay, what they call a LIRD. Okay, Life Insurance Replacement Declaration. Every company out there has a standardized form. Now, right across Canada, they all use the exact same form and everything. And it is a life insurance replacement declaration. So in that declaration, you're basically stating, here is why we are replacing this policy. These are the things that we find, let's say, deficient in the existing policy and why we need to go to a new policy. So as long as the client is aware that while you're doing it, and they sign off on that they agree that this makes sense, that we should go from this policy to that policy, then you're protected. If you just simply go ahead and do it, and then something happens to that client, and the policy, the claim, for example, is denied, you could find yourself in a whole bunch of trouble. So, for example, one of the most common ones is the suicide clause. Okay, when you replace a policy, whether it's with the same insurance company or a different insurance company, that suicide clause and the contestability clause starts all over again. None of us can sit here right now and say, well, my client is not a suicide client. I mean, the likelihood is impossible. He has a lovely lifestyle and everything else. None of us know that. None of us know that for sure, okay? And so therefore, it is very, very important that you protect yourself just in case something should go wrong, and then the client will, the insurance company will deny the client's claim and everything. So how do you protect yourself? Make sure that you have a life insurance replacement declaration on file. So file it with the insurance company. You have a copy with your client. Of course, keep a copy for yourself, so that in the event something does happen, and you are hauled in front of a court or something, then you can say, here it is. I did give the client ample understanding of why we're doing this, and he agreed to it. She agreed to it. Sign right here. Here's the proof and everything else. So you will protect yourself. So at the end of the day, basically, whether it was personal practice 1.0 or 2.0, at the end of the day, what is crucially important for you as an agent is right here. Okay, you must have errors and omission insurance. In other words, liability insurance. All of you, once you get your license, one of the things you're going to have is errors and omission insurance. You are considered a professional. A doctor has errors and omission insurance. Lawyers have E&Os. Accountants have E&Os. So liability insurance all around us. All professions basically have E&O insurance. Okay, why not you? Okay, so E&O insurance protects you against all the things that we've just talked about in both sessions. So the absolute minimum requirement is that you must have at least $1 million worth of errors and omission insurance. Okay, so in the event that something does happen, that you are going to be sued, okay, you have an organization that will stand up for you. So the very first thing you should do if you feel that maybe you are going to be sued, is to notify your E&O company. Don't call your lawyer or whatever. Call your E&O company and basically say, I have reason to believe that I may have a problem. They will then open up a file for you, assign that file to a particular lawyer, and then basically walk you through the whole process. So the very first thing you should do when you suspect that maybe there's a possibility of being sued, okay, is phone your E&O company and put in the complaint right away. Like I said, you open up a file, they sign a lawyer for you, and you just basically walk along with that lawyer then according to the circumstances and everything else. Okay, and that basically summarizes what is very important in that last chapter in the book. So I urge you, please go back, read it over on your own, because it is a very, very important area of our practice. And of course, we will see you next time.